discuss a very hot topic in our industry. A new case that was decided by the Arizona Court of Appeals on Tuesday. The case was released late Tuesday afternoon, and this is definitely going to impact planned communities and condominiums in Arizona. So the name of the case is AZNH Revocable Trust versus Sunland Springs Village Homeowners Association. It is a Court of Appeals case. It was decided or released on April 28th. And our firm's going to be sharing a link to the case on Zoom and Facebook Live. So if you want to do a deep dive on it, you can take a look at the case yourself and read the specific facts of the case. So what's the bottom line of this case? And I think I'm just going to make a few introductory remarks on this, in that I think we're really seeing a trend over the past decade of court intervention and legislative intervention to ensure that boards are being transparent and are not hiding things from owners. And this case is indicative of that trend over the past decade. So let's talk a little bit about what the ruling was in this case and how it's going to impact your associations. So first, does this case or opinion apply to Arizona HOAs and condominiums boards effective immediately? So my answer on that is yes. It's not like a piece of legislation where you have to wait 90 days until the legislative session is over. This case is now the law in Arizona, and all associations need to comply with it. So what are the practical implications of this case? I think it's probably not, needed to go into the specific facts of this case, but just a quick one-sentence overview of this case would be that it was the court's opinion that this particular association, Sunland Springs Village Homeowners Association, was making decisions in executive or closed session, and the court, for whatever reason, felt that was not being transparent. And so the court gave us some guidelines and tips for what we need to do going forward to comply with the ruling in this case. And so the bottom line is, here are the practical implications of this case for Arizona HOAs and condominiums. So boards can no longer vote or make decisions in executive or closed sessions. So no more voting on any topic in executive session or closed session going forward. Executive session is now going to be solely limited to discussion only of topics. And the topics that can be discussed are only the topics that are outlined in Arizona Revised Statute 33-1804A for planned communities and 33-1248A for condominiums. And the typical, subjects that we talk about in executive or closed session are going to be legal advice, violations, delinquencies, and personnel matters are the most common things that we're talking about in executive session. One last thing on executive session is that executive and closed session agendas must now describe the topic with particularity. So we can't just cite the statute, that we're going into executive session to discuss topics covered by 33-1804A. That's not sufficient under the law. We also can't just say we're going in to talk about legal advice and not give a more descriptive summary of what legal advice you're getting. How we handle executive sessions is changing going forward, effective immediately. So number one, no more voting in executive sessions. Executive sessions are for discussions only about the executive session topics that are outlined under Arizona law. And last, your executive session agenda needs to be more detailed. And I'm going to give you an example of that in just a minute. Okay, this law also applies to open board meetings, because if we're not making decisions in executive session anymore, we're making them in open board meetings. So basically the bottom line is, board meetings are going to be a time where all board decisions are made now during the open board meeting. And there needs to be proper notice and an agenda for all open board meetings. And again, agenda and notice for both open board meetings and executive sessions need to be sent out 48 hours in advance by conspicuous posting, email to all your residents, put it on your website. Those are all, adequate ways to provide notice. The agenda for the board meeting is going to need to be more detailed as well. So the board's going to need to list all action items on the open meeting agenda. And so that's another, I know a lot of you have been doing that, but you're also going to have to fine tune how you're going to list your executive session or closed session topics on your open meeting agenda. And I'm going to give you some recommendations on how to do that. One more practice pointer that we have from this case that I want to mention is that there's a sentence in this case that is a little bit problematic that I think that we need to do some fine tuning on something and some clarification on who sets the agenda. So in this particular case, the court remanded the case back to the lower court to determine if the president had the authority to create the agenda for this particular association. And so I think a safe reading of this case a suggestion would be for the board, your board, in its next open session to approve the association's president creating the agenda for all executive session and open session board meetings going forward, so that there's a paper trail that the president has the authority to do this. If your association wants a more collaborative approach on the agenda creation, then just state it that way, that the president maybe creates the agenda with the help of the manager, and then the president sends it out to the other board members to get feedback, and then the final agenda is created by the president after getting the feedback. I don't know how your association is managing the agenda right now, but I think it needs to be clarified in the minutes going forward. Most associations, it's the manager and the president are working together to create the agenda. That's, in my experience, that's typically what's happening. So we need to have meeting minutes that state how the agenda is created and who has the authority to create it going forward, in our opinion. Okay, let's talk about how we can create agendas to comply with this new law. So we're going to be sharing with you on our website a sample agenda for a closed meeting and an open session meeting going forward. As you're planning your meetings for May, that you have a good sample to help you comply with this new law. And so I'm going to give you some examples here that I think will be helpful for you and how you should word it. Executive session agenda, legal advice regarding enforcement of parking restrictions, and conversion of tennis court to pickleball court at our community. So you have to be real specific about what the legal advice is. You can't just say legal advice anymore. The next topic we're going to be discussing is review of homeowner violation matters and potential enforcement action. I think that is, enough detail. Discussion of owner delinquent accounts and collection options. And then consultation with legal counsel regarding pending or potential litigation. So you notice we're not using unit numbers, we're not using names of owners, and we're just discussing topics in this new agenda. And then I also would add a sentence that says, this executive session is closed to members. No final decisions will be made in executive session, and any formal action will be taken in a properly noticed open meeting. So I think those are some good tips for your executive session notice and agenda. Now let's switch gears and talk a little bit about the open meeting notice and agenda. I would just use the sample format that you've been using in the past for your open meeting agenda, but recognize that the court is clearly indicating a need to be more specific on the agenda about the topics you're going to be discussing. So put like your normal topics, call to order, homeowner forum, maybe at the beginning, and then approval of last month's meeting minutes. You can, do like president's report, treasurer's report, management company's report, and then new business, old business. Maybe you go into on the executive session topics that you need to vote on. So you can say something along the lines of executive session summary. You may want to give a summary of what was discussed, generally speaking. You could say the board previously met in executive session to discuss legal advice, violations, collections, and or other permitted matters pursuant to, and then we list the two laws that apply to planned communities or condominiums. And then you just have action items, votes to be taken in the open session regarding executive session matters that were discussed. And it could be, then you just reiterate the 4 ones that we just talked about. So a question, I attended a couple meetings last night, and a question to talk about this new case, and questions that were coming up from clients at those meetings were, should we be using names on the agenda of homeowners that might be in violation or delinquency? My advice would be no. Should we be using lot numbers on the agenda? No. When you're voting at the meeting and there's a motion, I think you do have to use the lot numbers. I would not use the names, but I think you do have to use the lot numbers so that there is a paper trail of what action you're going to be taking on violations or delinquencies. Okay, a question that I'm getting from clients now in light of this case is why bother even having an executive session, right? It doesn't make sense anymore. And I think what this case is going to do, practical implication is this case is going to move the only topics that we're going to talk about really in executive session are going to be like legal advice and personnel matters. Because violations and delinquencies, you're probably just going to move that discussion to the open session. So you may be having fewer closed or executive sessions in light of this new law. And the reason why you would always want to go into executive session when you're getting legal advice is I think that there should be a discussion of legal advice in most instances in a closed setting, especially if we're talking about like strategy on a case or that we might be involved in or legal advice on a controversial issue. I think it's important for the board to be able to discuss that privately with your attorney or receive the opinion from the attorney and have the board privately discuss it. And kind of the same thing with personnel matters. If you have direct employees for your association, or if you have independent contractors with your association, it could be discussed in the open session too, but it might be more prudent to have a preliminary discussion, like if you're unhappy with how the manager is doing or unhappy with the landscaper, a discussion could be done during the closed session where it could be confidential and the board can kind of strategize on how best to manage that situation. One other point on this case is, interestingly, there's also a bill pending in the Arizona Legislature right now that talks about this same topic, which is actually really kind of interesting. Senate Bill 1290 is moving its way through the Arizona Legislature right now, and it was moved back to the Senate on April 21st, 2026 for a vote with changed language. That bill only applies to planned communities, interestingly. But obviously this case is going to trump, that. And I'm not even sure that bill is going to pass now because in light of this new case. So just thought I would mention that. We're going to be talking about this case again later this month when we have our Neighborhood Services HOA Virtual Academy as well. What we're going to try to do is we're trying to move a lot of the questions that came in First Fridays today regarding the new case to the beginning, but we'll do our best to put them there so we can answer them in close proximity to us discussing it. Okay, the first case is from a homeowner. Will boards now have to vote on all issues in regular board meetings? This week, the Arizona Appellate Court upheld the Superior Court ruling that asserted that the existing open meeting laws for planned communities and condominiums limit and have always limited any closed or executive meetings to discussion or consideration of the 5 types of issues without the ability or authority of the board to take action in those same executive sessions. So, short answer on this. Will boards now have to vote on all issues in open board meetings? Yes, that is the short answer. Number 2, must an executive session be part of a regular board meeting, or can an executive session be held as a separate meeting apart from a regular board meeting? So this case doesn't change that. You can still have executive session. The timing on this is going to be kind of important though. My opinion is you're going to need to have your executive sessions before your open meeting. So if your board was having your executive sessions at the end of the meeting, that probably procedurally isn't going to work anymore, unless you're willing to wait until the next meeting to vote on issues, which probably most of you aren't. So I think the order of the meetings is going to change. Your executive session will be first, where you discuss things, and then you go into the open session to vote on them. And so it doesn't, they are 2 separate meetings. If your board wants to discuss executive session topics during the open session, you can do that. I mean, you've always been able to do that. You have the choice to do that if you want to. Okay, I think that answers that question. Number 3, from a board member. When a resident brings an issue to the board, we invite them to present it either during the open meeting or privately in executive session. In either case, the board's discussion and final decision on the issue takes place in executive session without the resident present. The resident claims this is an abuse of executive session and that they have a right to be present during the board's discussion. Are they correct? Okay, so there is a section in the Planned Communities Act and the Condo Act that talks about an owner being able to move their appeal to the open session if they want it to be in the open session. So I think that this would fall under this category if the owner requests to have that appeal of an issue. In open session, you would have to have it in the open session. Now, that's typically going to be like on a violation or maybe on a delinquency. Now, this question is maybe a little bit different in that maybe a resident's bringing an issue to the board. Like, I don't know what the issue would be, but, I don't even know if it's going to fall under the executive session topics. So it's hard for me to kind of talk about it. But, I think if it's an executive session topic that you're allowed to talk about, under the executive session statutes, then you can push it to executive session and have the board discuss it there. If it is not an executive session topic, it should be discussed during the open session. And then, of course, any voting on this is going to be done during the open board meeting going forward. So again, it's hard for me to comment on it because I don't know what the issue is, and I don't know if it falls under the categories of the executive session, but I think that answers your question generally. Question number 4. From a board, we understand there's new Arizona case law regarding executive board meetings focusing on the privacy of residents' issues. Will the HOA be able to refer to a case number rather than a person's name? So I think the question here is, if we have to vote on things in the open session in light of this new law, how do we maintain privacy of an owner if we're foreclosing on them or we're putting a lien on their property or we're sending a violation letter? So I think one way to do that would be to reference the lot number or unit number instead of using the owner's name when you're voting on things at the open session. You also could refer to a case number if that's, how your board wants to refer to it, although, not everything's going to be in litigation. Okay, next question, number 5. In regard to the new case law, does this mean records requests from members can be reviewed on past votes in executive session? Does it put past executive decisions invalid if not reaffirmed in an open session? So that's a really good question. So I think how I would approach this case is I would just draw a line in the sand and just do it right going forward. I suppose you could have your board make a motion to, ratify any prior executive session decisions that were made by your board, in this open thing. But you're going to have to go back years and years and years. And I think it would be better just now that this court has clarified this for everybody, just do it right going forward. And I don't think it puts past executive decisions, in some sort of invalid category. I think the court's now given us guidance on this and we need to just comply with it going forward. Next question. What is the A.R.S. number of the new law? Okay, so I think maybe we have a little confusion. This isn't a new law. Basically, what this is it's case law. So it's common law that the Court of Appeals in Arizona issued a ruling or an order or opinion regarding this issue. So our firm shared with you the link to the case. You just can read the case for the information about the ruling. It is not legislation, it is not a new law, it is case law, and it is binding on all Arizona condominium and planned community associations. On that note, I did say in my introductory remarks that there is a bill pending in the legislature that applies to planned communities that talks about not voting in open sessions anymore, but that bill has not passed. That bill number is Senate Bill 1290, if you want to look it up, but it's kind of irrelevant. I would go by what the case says at this point. Okay, number 7, if your board holds executive session meetings after the open session with this new case law, will they now need to hold them prior? So great question from one of my favorite managers. It is yes. From a practical standpoint, because the discussion needs to take place typically before the vote, this is going to need to be done out of the executive session first. Sometimes you may not need to. I mean, we're going to have to just see how this goes with how this new law plays out. But I'm thinking there's going to be fewer executive sessions, and most of the discussion and the vote on things is going to be in the open session now. And you're only going to go to executive session if you're talking about like a legal issue that you need your attorney's advice on, or maybe a personnel matter. But probably all violations and delinquencies, you're just going to discuss and vote on it in the open session now. But from a practical standpoint, yes, you should be having your executive session before the open session in light of this new case. Question number 8, for clarification, can we discuss specific fines and actions on violations and agree on figures in executive session if we provide an agenda item that we're going to discuss violations and possible fines in executive session? So yes, fines and, what legal actions you're going to take on violations are topics that can be discussed in executive session under the law. And so, yes, just make sure that the agenda item is clear, that you're not just putting the statute number out there, and that you kind of give more particularity about what the fines are regarding and what the, violations are regarding. As much detail on the agenda as possible for the executive session, the open session going forward. Okay, question number 9. Since liens are available on the recorder's website and civil cases are public, why the secrecy in executive session? I mean, I think there's some privacy concerns that have always been an issue that were raised by owners. They don't want their names discussed, but you're right. These things are open to the public. So I agree. It is what it is. You can find this information, but you have to look for it online. I think boards were cautious about putting that information in meeting minutes and discussing them in open sessions previously because they didn't want to get sued by the owners in case they made a mistake and the owner was current. But it is what it is. Now everything is, moving to the open session. Number 10, when exactly does this new legislation take effect? Okay, so again, we got to make this clear. It's not legislation. It's a case law. It's a decision by the Court of Appeals, and it took effect on the day that, it was released, April 28th. And we're drawing a line in the sand and saying, going forward, we are following the parameters of this case. And, that's it. So we had an executive meeting last night, and we did vote. I got this question last night as well. So, you may not have been aware of how to apply this case to your association. So just draw a line in the sand and going forward, do it right. What I would do to be safe is if you did, anybody who took an executive session vote after April 28th, maybe you had a meeting on the 28th, the 29th, or the 30th, just reaffirm the decision in the open session that you took, after April 28th at the next open session meeting. Thank you, everybody, for being here today. Great turnout. Really happy the timing on this worked out where we could talk about the new case so quickly and get the information out to all of you so that you can comply with the new case.